All right, people, I believe we are live. If we are live and you can hear me, I don't know, leave a comment or say something like a big Y or something. Mic check 1, 2. Get the angle straight. Okay, people, welcome to the stream. Robert Barnes is going to be here sooner than later. He is not yet here, but he has been very reliable thus far in our relationship of online streaming. Okay, good. So it looks like we're here. I'm going to say hi to some people who are in the chat. I'm going to say whose names I can say without, I hear a kid coming downstairs. I thought I was safe in the basement. Edwin Fish, what's up? We got Yonzo Heras, Kyle Nova, Neelium. Then we got Viva Frei, what's up? Okay, people, that's it for the intro. I just got the notification that I went live. So if everybody gets this, tweet it out, share it on social, because sometimes people tell me that they only get the notifications for the live streams tomorrow, which is extremely frustrating. Let's see. Standard rules for these streams. I guess I should say I do my best to get to all of the super chat. I invariably miss some. Working on a shirt that says "You missed my super chat" in quotes. We'll see if if I can get around to doing that. I do my best to get to the super chats. If I miss them, I apologize and just forgive me in advance because it's probably going to happen again. Don't spam the comment section. I noticed that is the leading cause of people getting time outed or whatever it's called. Spamming that interferes with the otherwise open, free, and meaningful discourse of the chat. And smash that like button. That is the other thing. And share, smash, like. Okay, so tonight we are talking about, let me just go to my DMs and see if I have any messages. I don't as of yet. We're talking about a few things tonight. I mean, I know questions are going to come up that are going to be related to other stuff, not necessarily to the declared or stated subject matter of this stream. Covington Catholic Kids. For the vlog on Friday, for those of you who actually listened to the entire 30 minutes of Barnes pleading, well, it wasn't just Barnes. It was Barnes and Elizabeth Warren's counsel pleading. They were in front of the Court of Appeal pleading on the successful motion to dismiss the Covington Catholic Kids, John Doe's, I think it's 1 through 8, but it might be more, the lawsuit against Elizabeth Warren and Deborah Holland on the basis of sovereign immunity. It's first of all, it's tremendously fascinating to listen to. STFU, FFS, thank you. Happy Sunday. You just made my whole weekend. My pleasure, STFU. FFS. I know what that means. It's tremendously fascinating to listen to. Our Court of Appeal works in the same process, sort of by the same rules. You get a certain allotted time frame, and they're pretty strict about it. But generally speaking, like in the Superior Court, man, you can go listen, and it's not concise, limited to 15 minutes rebuttal, response time that people respect. It goes on for it's haywire. This listening to the pleading in front of the Court of Appeal, it was pretty strict on the time. But it was just amazing to listen to the lawyers plead. I'm aware of my problems when I speak about speaking quickly. I tend to slow down when I get in front of a judge and make sure the judge is paying attention and listening. But it's always a deliberate effort for me listening to Barnes and listening to the other lawyers involved. They pleaded very well, and they pleaded well on the substance and on the form. So that was it. Let's see. That was fascinating to listen to, and surprised how Barnes could stay quiet. Vicky, one other thing. I've been told to read the chats slower because some people are not looking at the screen while I do the stream. So I'm going to do my best to do that. That was fascinating to listen to and surprised me how Barnes could stay quiet. Vicky Rose. It is the hardest thing that I have in terms of the practice of law is you have to stay quiet. You can't jump in and intervene every time somebody says something that you vehemently disagree with. You have to take notes and make sure to come back to it, and you have to address it in order. And it's the most frustrating thing to listen to somebody mischaracterize your position, and you have to let them do it, because if you interrupt and yell at them, that doesn't fly in a courtroom. It flies on Twitter, but not in a courtroom. What do we got? Dapper Dave says, a lot of us disagree with your Owens comment. It's not the end of the world. I mean, I noticed a lot of people disagreed with it. A lot of people agreed with it. It's not the end of the world to disagree with someone who you still respect. I listen to a lot of Amazing Lucas. I disagree materially with some things that he says, and I agree with a lot of other things that he says. But You never, if you agree with someone on everything all the time, something's wrong. And disagreeing is one thing, because people can have diverging opinions and assessments. But if you think that someone's opinion is untenable, reflecting ignorance, intolerance, or lack of understanding, that's another thing. You can disagree with my opinion. I don't think one can say that it demonstrates a lack of understanding. I understand her point. I understood her point from the very beginning. I've been following Candace for a long time. I know her points, and I know the substance of what she says. So disagreeing with it is one thing. Thinking that it displays bad judgment or wrong judgment, that's another thing. So that's it. Now, so the Covington Catholic Kids, they had their day in court on Friday or Thursday. It was Thursday. Or it was Thursday. It was Thursday. And they pleaded why the dismissal against Elizabeth Warren and Deborah Holland should be reversed, and why sovereign immunity should not warrant dismissal of the suit at this stage, at the very least. Perhaps later, and certain things they discussed, which Barnes and I will get to. Hope he didn't forget. If and when. But so that's going to be one thing on the menu for tonight. The other thing is the Flynn update, because it's just never ending, and they just had their hearing on Friday. That's it. Flynn was on Friday, Barnes was on Thursday. And that's a never-ending story that is just incredible. Barnes is here. That's a relief. So we're going to talk about that as well. We might talk about the Jussie Smollett thing, the double jeopardy, because it's just an interesting topic. I learned a little bit about it doing today's vlog, and the motion to compel documents, which is also interesting. But we'll get there. So we're going to do all of this. Daryl Wheat, do you think the court will side with Barnes and his clients? Okay, so we're going to get what Barnes said. But Barnes, I'll let Barnes answer to his own assessment. I said it's an uphill battle for Barnes because he's already dealing with a fait accompli, and he's got to undo that, or they have got to hope to undo that decision. So it's always harder to do that. Some of the questions they got into, I think, indicate the court's openness to it, where they were discussing sovereign immunity at the threshold stage, which was the stage of dismissing the suit under the Rule 12.6b or 12b6, versus at a later stage of discovery. Okay, but that we're already getting ahead of ourselves. So let's bring Barnes in. Oh, he's got a good backdrop today. But it's not good. That's not to say before it wasn't good. It's not a fish tank anymore. And he's got the trademark cigar. Robert, how you doing?
Good.
Okay, now, so people don't chew us out later on in watching the highlights. Are you on your camera, on your computer, or another camera?
So now I'm in Tennessee. So I'm in my Chattanooga office that has a Big Mac. So I got like a real computer, real mic, real headphones.
You got the Yeti Blue. Okay, very good. It looks good. Nobody has any complaints about the lighting or
yeah.
How you doing? You doing well?
Doing well.
This is going to be amazing because people have questions, and we're gonna clarify everything that was going on. So I'm always reluctant. I don't like, talking about pending cases. You're comfortable talking about the pleading that everybody listened to before the Court of Appeal?
Oh, yeah. I mean, there's some stuff I can't go into, but 95% of it I can.
Okay, so let's start from the beginning so that everybody understands the context. I think most people do, but anybody who's watching for the first time. Covington Catholic Kids, there were two parallel proceedings with Nicholas Sandman as an individual represented by L. Linwood, and your clients represented by you, who are John Does, for reasons which you'll explain. First thing, actually, before anybody says anything, on Twitter, I noticed that Nicholas Sandman, said that you had blocked him on Twitter, and I strongly suspected that was to make clear to the entire world that you're not representing him as a client, so there was no more confusion as there was in the past.
Yes, his local council is running for Congress against Thomas Massie. And so that has created a wide range of issues. And there had been some prior areas where, let's just say, we have different legal and public opinion strategies about this. I'm not running for Congress, so I don't have any particular motivation in that regard. And so ultimately we came to an agreement that I wouldn't say anything about where I disagree with them, and they would just stick to their own case too. But as part of that, I've been told that was Nick Salmon's account. I'm not sure. there was a point in time in which he was making, someone using his account at least was making negative comments about my clients. And so I thought that was not productive for anybody's purposes. And so ultimately the best resolution was to block everybody associated with that. Okay. And came to a resolution in that regard. But yeah, so that's still accurate. I've never received confirmation that that's his actual account. It may be, but I've never received that confirmation. But someone tweeting from that account was attacking my client, so that's why I blocked him. Okay, and now be careful hitting the cable on your microphone. It's making a crackly noise. I don't want anybody getting angry about that. Okay, so that's interesting, and I just wanted to clear that up, because I suspected that was. I know from an article that I found in Google that there was some back and forth among counsel a little while back, and confusion as to who people thought people were claiming to represent, and I figured that probably was the most logical explanation. Okay, so parallel sort of lawsuits. You're representing the Covington Catholic Kids. You've explained it before, but why did you want to keep them anonymous again in the pleadings? So 2 reasons. One, they wanted to stay anonymous, and because they'd already had enough fame for a lifetime, didn't want any more of it. And so their goal was to stay anonymous from the inception. And the question was, could they stay anonymous in a way that and still bring suit and seek remedy? And my view was that so first of all, it was their priority was to stay anonymous. But the reason why I wanted to pursue the case even so was because I thought they should be entitled to do so. My view is, in order to prove invasion of privacy, you should not have to forfeit that privacy as part of seeking remedy. And in particular, in the doxing context, you should not have to dox yourself in order to bring a claim against someone for doxing. And so here, while they had been doxed, they had not been doxed to the entire world. They had been doxed to about 10% of the world, probably 80% of their local community, but even there, not to everyone. And the more they could protect their privacy, which is what they're seeking in the suit is to do, the better. So to me, it made sense. I wanted to establish as a precedent that you could seek to protect your privacy without waiving your privacy in the process. Okay, very interesting. Now, I'm going to read these super chats, but we're going to get to them in due course. Do you think the court will side with Barnes and his clients? Obviously, Robert, you're going to make your own prediction, because I think it's a legitimate question. How can opposing counsel get away with saying the kids were harassing the native elders when the video shows different? They're not being honest. They're representing their client's interests, but we'll get there as well. To keep Robert in cigars. Even the defending attorney said that immunity needs to be delineated by the court, which is a main point of the plaintiff jury trial. Explain, and we're going to get to that as well, because that's the amazing thing. Okay, so thank you all, by the way, for the super chats. So you kept the plaintiffs anonymous. You sued, and we've done streams on this. We've talked about it. Warren and Holland moved to dismiss. They moved to move the case to federal court. It was moved to federal court. Federal court says, okay, now we're dismissing it on the basis of sovereign immunity. I was a little confused about this for a while. Can you explain the two provisions or the two legal statutes? You have the Westfall Act and you have the federal. Finish my sentence, because I forgot it now. Federal Tort Claims Act. So essentially what you have is the Federal Tort Claims Act is a waiver of sovereign immunity for particular kinds of claims. And you have to bring it pursuant to you have to exhaust your administrative remedies. You have to bring it in a certain procedural manner. You have to bring it in a particular court. And it's only a waiver of sovereign immunity for certain kinds of claims. So in particular, there is no exception. There is no waiver of sovereign immunity for libel or defamation under the Federal Tort Claims Act. So the Westfall Act was written in response to the U.S. Supreme Court case known as Westfall, who was one of the parties. And what happened was the U.S. Supreme Court said, you know what, immunity is really limited to certain categories of actions and activities. So they changed how immunity worked based on whether you had discretionary authority or not for doing what you did. Congress did not like that. So that's why they passed an amendment to the law that said, no, we're going to overturn the Westfall decision and make it clear you have full immunity, regardless of whether it's a discretionary duty or a ministerial duty that you're up to. The U.S. Supreme Court subsequently interpreted the Westfall Act to simply codify what the immunity law was prior to its Westfall decision. However, whether they intended to or not, there's some people that would have a darker view of Congress. It was very quickly interpreted, the Westfall Act was to expand immunity to people that did not have it before at all. Because traditionally, I know there were a lot of people commenting on the video talking about parliamentary privilege. The Speech and Immunities Clause of the U.S. Constitution essentially enshrines within the Constitution the protections of parliamentary privilege, and similarly limits it so that you cannot be sued for libel or defamation for anything you say in the halls of the Senate or Congress or the House, but you are completely unprotected for things you say outside of the Senate or the House under the Speech and Immunities Clause. Well, all of a sudden, with the Westfall Act, even though nothing in the legislative history said anything about this, and no politician said, by the way, I'm giving myself immunity, now please reelect me. That did not happen. About a year or so after the Westfall Act was passed, Operation Rescue, a anti-abortion group, pro-life group, depending on where you are in the political spectrum, how you label them, sued Senator Kennedy for making statements that they called defamatory at a fundraiser in Boston. Now, the judges who would preside over that case, Kennedy was the first one to say, you know what, the Westfall Act actually expanded immunity, so now it applies to things outside of the halls of the Senate or the House. And as long as it has any kind of relationship to my job or duty, I have official immunity. And since there's no waiver under the Federal Tort Claims Act of sovereign immunity for a libel or defamation claim, neither I nor the United States can be sued. I should go back briefly. The Federal Tort Claims Act allows you to substitute the United States for the person you're suing. And the United States agrees that it waives its sovereign immunity for certain kinds of claims if the employee was acting within the scope of their duty. The Westfall Act just defined what was their duty or not, and that it could be a non-discretionary duty for which they're immune, as well as a discretionary duty. That's the way the two acts work together.
Okay, so the Federal Tort, we'll call it the Federal Tort Act, just because I miss the third word every time. It included waivers, but it did not include a waiver for liability. Sorry, a waiver for defamation. Sorry. Exactly. Which means not including the waiver for defamation means you could sue for defamation under the Federal Tort Act.
No, you can't. In other words, if somebody's acting within the scope of their duty, so here's how the Westfall Act and the Federal Tort Claims Act sort of work together. What happens is if you are suing someone that's an employee of the United States and you believe what they did was within the scope of their duties, then what you're supposed to do is you're supposed to sue the United States. If you fail to do that, the United States can then intervene in the case through the Attorney General's office and say, actually, this individual, this individual should be removed from the case and it should be renamed the United States because this is actually a case against us because the employee was acting within the scope of their duty. But then what happens next depends on whether there's a waiver of sovereign immunity. So stage one is they say this was actually within the scope of their duty. So under the combination of the Westfall Act and the Federal Tort Claims Act, we're going to intervene and replace them. And so if you've sued in state court, they remand it to federal court and they tell the federal judge, we've certified, the Attorney General files a certification. We've certified this person was acting as an employee. And so we want to substitute in the United States for that party. So Operation Rescue goes from Operation Rescue versus Kennedy to Operation Rescue versus the United States. Then you get to a second analysis, which is what's the outcome. So if the Federal Tort Claims Act provides for a waiver of immunity for the claim that you brought against that employee, then you move forward against the United States in the suit. If they haven't, then the United States moves to dismiss on sovereign immunity grounds.
Okay, good. Now I hope that's clear for everyone. That's sort of much more clear for me. And incidentally, so do we know why the United States did not move to substitute for Warren or Holland in this case?
My view is it's because they did not believe either Senator Warren or Congresswoman Haaland was acting within their official duty, and that the Attorney General was not going to certify that. Now, the interesting thing about that process is that there are actually three ways to have that happen. One, you as a plaintiff can say that the United States should intervene and certify that they are defending the case. The United States can do so. The United States can move, the Attorney General can certify and move to intervene, or the defendant can request that the federal district court order the Attorney General to certify if, in fact, certification is appropriate. What was unique here is we did not sue either Warren or Howland in their official capacity. They individually removed the case, but never sought certification from the Attorney General. And then they did not ask the judge to request the Attorney General to intervene. And the only logical conclusion to me is that they believe that the Attorney General would reject their certification request, that the Attorney General would say, no, this was not done within the scope of their duties as employees. And I'm sure particularly Attorney General Barr was not going, in the Covington case, he was going to say Senator Warren was acting as her official obligations as a senator when she defamed a bunch of kids. I don't think he had any inclination to do that. I think they knew that because otherwise it made no sense for them not to pursue it or at least try it. The only reason not to try it was to put on record that the Attorney General rejected a certification request. I could not force the Attorney General to reject it myself, but they could have. But they must have been worried that that was a high probability for them not to do it. Very interesting. All right. And Joshua Cornelius says, I had a real problem with the constant characterization of the harassment of the tribal elder. How is this a factual argument, and how likely is the court to be swayed by that kind of rhetoric? Well, okay, we're going to get there, Joshua, and thank you very much for the question in the super chat. Okay, so that's I think that's much clearer now. So they successfully had the case dismissed on the basis of the sovereign immunity, and you appealed the decision. Now, a lot of stuff was said in there that I'm not sure I totally understood the nuances of, where there was statements, the reference to the Kennedy lawsuit. Do you want to elaborate on that and explain in detail what the application of that case is to this one? So how all of this evolved is that the speech and immunity clause cases, particularly in the 1970s, the U.S. Supreme Court made clear that only statements that could have led the king to invade the parliament were the kind of statements that they were trying to protect, and that those are statements made either on the floor or had a close correlation to pending or proposed legislation. And they made clear that nothing else applied. Nothing else was really within the legislative duties or tasks. And they made that first in the Gravel case, and then after that in the Hutchison v. Proxmire case, 1972 and 1978. Then comes the Westfall Act, in which nobody's talking about this somehow changing the law of immunity. And as the U.S. Supreme Court would rule in 1995, they would say, all the Westfall Act did was restore the immunity that previously existed. Well, despite that, a few courts, I think only 4 courts in the country, have issued published decisions about whether the Westfall Act expanded immunity beyond the speech and immunity clause for defamation and libel claims. And it was convenient for the Congress that the first case involved Ted Kennedy. So Ted Kennedy made his statements at a fundraiser in Boston. Operation Rescue brought suit in Boston. I would have recommended they not do that, but that ship has sailed. That was 30 years ago. For example, to give people an idea, the First Circuit Court of Appeals also sits in Boston. There's not a single judge in that entire circuit or district that did not get his approval from Senator Kennedy before he got on the bench. So even if the Republican had appointed them, they had to get pre-approved by Kennedy to be there. So you're asking a bunch of people who owe their power to that senator to say he can now be sued. It wasn't going to happen. But the fortunate thing is the courts, and what they focused on in those cases really wasn't the arguments I'm making. They focused on the first argument Operation Rescue made was, hold on a second, nobody thought the Westfall Act applied to members of Congress. They were shocked by the suggestion. They didn't understand the political dynamic fully they were in, but or they wouldn't have brought suit where they did. So that was the argument, was whether or not Congress was included within the Westfall Act. Under its plain language, they were. under the legislative history, there's nothing that talks about this. But that I never thought that argument was going to be very strong. But that's what ends up being litigated. And what the district court says in that case is it says, look, Kennedy was responding to a press inquiry about pending public policy of a hot button issue. And so even if what he said was false about Operation Rescue, it's in the context of his duties as a senator. And what they're really saying is if he was not a senator, this question is never asked and he's not discussing it. He's discussing it because he's a senator. The press member who's asking him the questions is asking it on behalf of his Massachusetts constituents. It's a local Boston media network. And so now, while I view politics as what motivated that decision more than anything, their legal basis was the district court used some language that I knew I could utilize, because it went out of his way to say these were not gratuitous statements. These were not statements that came out of nowhere. These were not statements that were for personal motivations. These were for public policy because of his position as a senator. That's the first case to decide whether the Westfall Act expands liability. Then there are about 3 subsequent cases, 2 of them within the D.C. circuit. One goes up to the circuit, one decided at the district level, and then one in, I believe, Texas, maybe Oklahoma, that goes up to the 5th Circuit. And all of them expand immunity a little bit more. So Congressman Murtha is sued for statements he makes at a press conference about an ongoing investigation concerning a private citizen. That private citizen sues. Congressman Murtha says, hey, this is about an investigation that I'm the chairman of the committee and I was answering a press inquiry, and it's right within the Operation Rescue doctrine. Murtha was a very popular congressman in D.C. He sued in D.C. Not surprisingly, they expand immunity and say, oh, it applies to him too. Then later on, another congressman is sued by CARE, which is a Islamic Relations Council for American Islamic Relations. And this one I thought was a ridiculous decision by the courts. It didn't serve my purpose to argue that in front of the 6th Circuit. But what they did is the congressman attacks CARE. He does so in the context of answering a question about his divorce. But he's saying because CARE somehow was connected to his wife's neighbor or something. And so he just goes on this long libelous thing about CARE. So CARE, of course, sues. And he says, golly gee, I same thing. I just like Congressman Murtha, just like Senator Kennedy. That was part of my duties. I had to libel those poor people. The D.C. Circuit decided, that makes sense, and expanded the immunity to cover them. None of the people in any of those cases made the argument that I made in Warren. Always the best argument was there have to be limits here. And if not, you've just given election to Congress a license to libel. And that was something no judge was going to feel comfortable with. But astoundingly, in the 30 years since the Westfall Act was passed, I am the very first person to make that argument to any federal court. There was a 5th Circuit case of a comparable, was like the D.C. case, and they went along. The 6th Circuit has never addressed it. No judge within the 6th Circuit has. And to give people a background, when I first brought this suit, a lawyer went on Tucker Carlson, and there were lawyers all across the board telling me all the people I could not sue and so forth. And she went on even Tucker Carlson and said, she didn't refer to me as Barnes. She just says, that lawyer. God bless her. And so she said, oh, you can't sue Congress, period. There's no chance you can sue Congress. The reason why these cases have not been litigated is because all the lawyers quit before the fight began. I've never known anyone to win a fight who did not go into the ring in the first place. And so I looked at the law and I knew the legal background for it. And I knew that to a certain degree on paper, it was uphill. It was uphill because all the lawyers were saying you can't sue a member of Congress. But public policy wise, that did not make sense. Constitutionally, that did not make sense. And practically speaking, if I was a judge, I would not want it to be limitless. And so that's where the great utility here is. I told people, look, there's one of 3 outcomes I can get. Either they say, you know what, Congress is completely immune. If that's the case, I have a great argument to change the law to go. I already have congressmen lined up considering it, saying this is insane. Look at the Covington case. The court said that you're completely immune just because you're elected to Congress. And some smart member of Congress will run against Congress. It's always a smart way to do it. And actually, there's a good one who may be doing it himself, which is Congressman Thomas Massie from Covington, Kentucky. His primary opponent happens to be the Nicholas Sandman lawyer. I'll say nothing more. And so he might introduce the legislation to remove this in case the 6th Circuit says, oh, there's complete immunity here. Option 2 is what actually happened at the appellate argument stage, which is I got the other side for the first time ever. because those lawyers are representing Congress technically, even though they're representing the individual defendants, they've been hired by Congress, to admit on the record that there have to be limits. That's the first time they've ever said that. It's what the big prominent DC lawyer and Tucker Carlson said, there were no limits, and any lawyer is nuts who thinks there is. Well, I already got them to concede their limits. So now the only question is, do the limits benefit me in this case or not? Even if I don't win for my client, the clients get a big outcome that they want, which is establish that there's at least some sort of limit. And then we're only debating where the limits apply, no more that it's limitless. Or third, I get the courts to come in and say, you know what? Barnes is right. No court has ever said that this applies in this kind of context. We don't like this kind of context, so we're going to impose the limits ourselves, and the limits are going to protect his client. But in my view, I couldn't lose here. One way or the other, I was going to change the law by bringing the case. And actually, a question that I have before we get there, I'm just going to read this. This is STF UFFS says, infuriating opposing counsel using the phrase Native American tribal elder, a gross mischaracterization to anyone who knows the context. Phillips was acting as an agent of the Black Hebrew when he approached them. And we incidentally, YouTube actually changed their terms of service to say you could no longer attack someone's credentials as an elder shortly after that. And Robert, that lawyer Barnes, thank you, sir. So first things first, I mean, it's all fascinating. And I want to get into the three options that you described, but at this stage, they're not even coming to that determination. What they're saying is we're going to move this back to the lawsuit, reinstate the lawsuit, and if the sovereign immunity comes up at a later date subsequent to discovery, then maybe they can present that argument again if the evidence supports the idea that these statements were made somehow in an official context. Right now, we don't know, so move forward and don't have the de facto dismissal of the suit just because it was a congressman that said it. And now I understand the 3 points even better as to what you were getting at. Is there not a risk that they're just going to they're going to come to something of a hybrid piss everybody off decision? They're going to kick the can further down the street and say, yeah, this was somehow indirectly or directly, this was indirectly related to their functions. So this might not be the case to determine it. We'll wait for another more clear-cut case of a senator, insulting their neighbor with no plausible connection to policy. Right? Is there a possibility they do that and everybody loses in this? The only way they could try that is to go to the personal jurisdiction argument. But the problem they have, as Warren's lawyer reminded them, is that they can't get to the personal jurisdiction issue until they get to the subject matter jurisdiction issue. So the way I set this case up to make sure that this issue had to be addressed by the courts was I filed in state court. I didn't file in federal court, and I didn't allow any grounds of remand. I didn't sue for certain amounts of money that would have allowed for remand. The only grounds that they could move to remand on was going to have to be the sovereign immunity claim. So that's why they cannot address the personal jurisdiction question without first saying the federal district court had subject matter jurisdiction. It can't say they had subject matter jurisdiction without resolving the scope of immunity question. So that's why they're sort of stuck I created the procedural circumstance where I was going to force the courts to address this, particularly if the other side took the bait. If Warren and Howland took the bait to remand to federal court on these grounds, then I was perfectly situated to make the federal courts address this question with this fact pattern.
Okay, and just so everyone understands, remand is change of jurisdiction from the state court to the federal courts because they have overarching jurisdiction. You want to explain the difference between subject matter jurisdiction and subject matter jurisdiction and personal jurisdiction?
Absolutely. So state courts are courts of general jurisdiction. So they can usually hear any subject matter dispute. And the only question with state courts is personal jurisdiction. Sometimes they don't have authority over the person, but they almost always have authority over the subject matter because they're courts of general jurisdiction. Federal courts are not courts of general jurisdiction in the United States. They're courts of limited jurisdiction. Depends on what the statute and the Constitution allows them to have. And so in that context, federal courts can only hear disputes where Congress says, we give you the power to hear these disputes. Now, they can argue certain constitutional issues. They may have inherent jurisdiction, but putting that aside for the moment. So in this context, I'm suing under state law, Kentucky law, for Kentucky plaintiffs against out-of-state defendants. The only way they could normally get the case in the federal court was if I sued for more than $75,000 per defendant, per plaintiff. I did not. I deliberately sued underneath that amount. which means the only way then that a federal court has the power, the right to even adjudicate the issue, is to have jurisdiction over the subject matter of the suit, is if they have a defense that arises under federal law. Then they can go to the federal district courts and say, hey, federal judge, you're better situated to handle this because this is a defense that arises under federal law, and that gives you subject matter jurisdiction. And I also deliberately chose to sue them in their personal capacity. So the only way they could do so is they'd say, oh, really, the plaintiffs brought this suit, misidentified it as a personal capacity suit. It really is supposed to be an official capacity suit because it gives rise to sovereign immunity claims. And so they're really suing us for what we did as employees of the United States. They're not suing us for what we did in our individual personal capacity. And that's where, in this context, the judge cannot rule. Now, the second question is whether either the state court or the federal court has jurisdiction over the person of Senator Warren or Congresswoman Haaland for the purposes of this case. Personal jurisdiction in the United States depends on what the defendant did, not what the plaintiff did. So does the defendant live there? Does the defendant have constant business contacts there? Or did the defendant commit the tort there? Now, in the United States, there's also a due process limitation. State courts are not allowed to assert personal jurisdiction where it would offend the due process clause of the Constitution. In this context, there's a case called Calder that went up to the United States Supreme Court that the U.S. Supreme Court said, because defamation pretty much can happen anywhere, every state in the union has a due process interest in defamation being adjudicated in their court. And so that's why due process-wise, there was no question we had jurisdiction, either in the state court or the federal court. But the second question was whether or not under Kentucky law, it requires an additional element. It requires not only do you have to have due process, the tort has to have been committed here too. So it's one of the few states that requires. Most states just say whatever due process allows, our state laws allow, not Kentucky. But the tort of defamation is generally committed in Kentucky under Kentucky law, where someone intends to have the defamation occur there. So under the effects test, that's just did the effects happen there. That conforms to due process. But the higher analysis under Kentucky is the defendant has to have intended those effects to happen in Kentucky, and then you have personal jurisdiction. The same Judge Bertelsmann has ruled in another case referenced at the oral argument in a different Doe versus Griffin case, but arising out of the same set of facts on behalf of other Covington students, because there are about 4 different lawyers representing 4 different plaintiffs in Covington cases. I represent 8 of them. 2 others represent a group of people, and then Lynn Wood represents Nick Sandman and the local lawyer there who's running for Congress. And so who they recently caught with some unfortunate tweets, but skip that story for now. But so as that part of the case proceeded, the problem for Bertelsmann was, so Bertelsmann has ruled in a separate case, no personal jurisdiction under these laws in this case. That's because Bertelsmann, frankly, doesn't want to deal with these cases. So there's a reason why he got stuck reversing himself in Sandman. It was because they dragged us back into the case. They dragged us from state court into federal court. Griffin and Warren and Haaland initially moved to dismiss on all of them moved to dismiss. They moved to dismiss on the congressman, the senator on sovereign immunity, but they also moved to dismiss on personal jurisdiction, as did all the other defendants. And they all moved to dismiss on saying that no claim was made. So we had like 100 briefs to deal with in a month time period. So it was a massive amount of research and work that went back. But the advantage, they made a mistake by doing that. They were letting us brief Judge Bertelsmann on the same issues he was considering about reversing himself on Sandman. And we made a bunch of arguments that Sandman's counsel had not made. And he actually some of the language he utilizes parallels the arguments we were making, which our point was, look, a lot of these things are facts. A lot of these things are not actually protected opinion. And here's how and why. And in fact, some of them are criminalized under Kentucky law. Things like there's a statutory definition of harassment under Kentucky law. Certain forms of blocking and trespass can be considered criminal under Kentucky law. So it was our arguments he ends up implicitly referencing when he reverses for Sandman. Sandman's cases may have never been reversed, but for these other defendants, particularly Warren and Howland, dragging us into federal court, thinking Bertelsmann was on their side and giving us a chance to make much better and enhanced arguments, because we're arguing against 8 different defendants at the same time, massive amounts of brief writing. I had pre-written a lot of these briefs. So we got him reversed on that. And what Bertelsmann does is he sort of splits the baby with our cases. He says, I'm going to let the politicians off, and the rest I'm going to send right back to state court. I'm not going to deal with this. He never talks about personal jurisdiction because it really makes no sense to get there. Because that's why when they were saying it was alternative at the Court of Appeals, it's not really. And you notice they didn't have many questions about it, because they can't get to personal jurisdiction unless they first find subject matter jurisdiction. But if they find subject matter jurisdiction, that means they're immune. So there's no reason to deal with personal jurisdiction. The sovereign immunity disposes of the case. That's why it's it's almost impossible for them to punt. Had I initiated the case myself, then they could have punted. Then they could have said that Barnes initiated the case here, we'll dismiss on personal jurisdiction. If I sued in the wrong way, such that they could have remand on different grounds other than immunity, then they could have dismissed on personal jurisdiction. But now they can't. And so I don't think they'll embarrass themselves. All 3 judges are pretty sharp. For people who, I saw a lot of questions on the comment section about the video, wondering what kind of preparatory review goes into this. And a lot does. So as soon as we know who the judges on the panel are, some courts you don't know till the day of. In this case, we knew a couple of days before. If you're lucky enough, like if you're on the weekly panel and you're on Thursday and they tell you about it all on Monday, then you get about 3 days to prep. These 3, everything's about know your audience, KYA, which is as important as KYC and CYA. Is to research everyone. And we had one judge was a Clinton appointee, older African-American judge. Another judge is the judge who asked all the questions. Most of the questions is a Trump appointee. The third judge is a weird hybrid. She was originally nominated to the bench by Bill Clinton, but because the Republican senator in Michigan was mad at Clinton for other reasons, her nomination never went through. Flash forward almost 10 years later, and as a compromise with the Democratic senators, George W. Bush is the one who puts her on the bench, though every Republican will vote against her nomination. So what I really had was 2 Clinton judges and 1 Trump judge. I figured the Trump judge would likely be aligned in our direction, and that my hurdle was going to be the 2 Clinton judges. Luckily, I had no Obama judges. In my experience, Obama judges have been the most results-oriented judges I've ever dealt with in my legal career. We saw it again in the FLynn case. You should not be that predictable as a judge, to where I know what the politics are and I can take the exact same fact pattern, change the politics, and I know you'll change your opinion. And so I was thrilled when I saw no Obama judge. That meant I was in the game. And so so there was a reason why we cited the cases we did. And my takeaway was early on that there was, like, some people were wondering why the other side was bringing up certain fact patterns that are actually in controversy and disputed. All the judges know that. It's because that was the specific language of Warren's tweet. Warren's tweet was Native Elder American harassed. That's why they could, quote unquote, get away with saying it over and over again. They were just repeating what the tweet was. But they know we dispute the truth and accuracy of it.
Well, I mean, and at this point, I think they understand that it was just, it's not accurate. The only question is going to be, not even whether it's defamatory, but whether or not there's immunity for whatever defamatory aspect there was to it. Because I think everybody understands it's not what happened anymore. I don't think there's very many people who still stand by that narrative. And it's actually a good time I could pick up Jason McConnell's tweet. Wait, the tribal elder was referring to the guy with the drum. I thought they were talking about Warren. You can always count on Jason McConnell for a good joke. And then we had, I'm going to bring this up. We're not going to answer it now, but Aloysia, could you guys go into the denial of the 14th Amendment rights to pre-existing property holders in the Chaz, mayor's exposure, etc.? Definitely a subject matter for another stream. I don't think we're going to get to that today. We got Life of Brian. It's about how sharp the judge is. It's about what pictures. Okay. Sorry, I have that one. I'm stopping to read. I don't want to get into certain trouble based on the tweets, based on the super chats. And we got Jonathan. When can we expect your Law and Order theme base cover video? we'll get Davey 504 to do that one. Okay, so, and it's an interesting thing. First thing, I've mentioned it in previous vlogs, but it's amazing to hear you talk about it. When you know your judge, who your judge is going to be, you do an amazing amount of research to not to tailor or to what's the word I'm looking for? Not to cater to that judge, just to know the judge.
Oh, well, yeah, exactly. And you know what's likely to persuade them, what's likely to motivate them, what kind of obstacles you face. The other thing is judges will educate you. So in about 85% of cases, a appeal by various statistical surveys that have been done. People like Mark Gallanter at the University of Wisconsin, some others do a lot of this sociology of the law kind of analysis. If you can know who's going to win, just if you know how many questions are asked each side. And what this reveals is most of the time when in the United States, in my experience, when the appeals court comes up to ask questions, they've already made up their mind. And what they do is in contrary to what some people think, if you get more questions than the other side, it usually means you've lost about 85% of the time, particularly if it's substantially more given the volume of questions. And the reason for that is because what they're trying to do is they're trying to force concessions from the opposing side, and they're trying to test how to couch their phraseology of their decision, depending on how you respond to certain words and questions they raise. In about 15% of cases, the court will be undecided when they come in, and that's often reflected by having 1, lots of questions, and 2, an even number to both sides, which is what happened here. So that's one of the things I pay attention to very early on is who they're asking more questions of and what are the kind of questions being asked. The other thing you also often have is by knowing the background of the judges, you know that there's a higher probability than average when you have a politically split panel that you may have judges using their questions to you to argue to the other side. So, for example, some people were startled that the judge who asked the most questions, who seemed otherwise sympathetic to our position by some of the questions he asked, interrupted me when I was explaining the Gravel and Hutchison Proxmire cases actually established all this stuff outside of the halls of Congress is not supposed to apply. He interrupted me quickly. He's like, oh, that can't possibly be the case. Now, he's a smart enough judge to know that's actually what the law is. I think what was happening, I took that as a signal that he was saying, look, the other judge, probably the deciding judge in the case, the judge who was appointed by both presidents, Clinton and Bush, he was signaling that's not going to be a persuasive argument. So just skip that argument. And he gave me a direction where he said, it seems more to me that because this really had nothing to do with legislation, beside the geographic coincidence that took place in D.C., that's a better argument to make, effectively is what he said. And so I always run with that. So some people are wondering, well, why did I push back on that? Sometimes lawyers get up there and they just want to argue the purity of the law. You got to read the room. And if you got a judge who's saying, go over here, not over there, and you think they're on your side, you follow them. So that's why I was like, yes, Your Honor. Very insightful. Absolutely true. Now, and transitioned into that area.
Okay, and that's the interesting thing is, I mean, I noticed that. What I thought was concerning about it is that it was giving an indication to the other two judges to find a way to tie these tweets to policy so that you can justify the lower court decision. And that irritated me because it sounded like that's what the two other judges were doing.
In fact, I think what happened is the reason why he was pushing me in a different direction was because I think he already knew the other two judges had come up with this idea that they were going to say if a tweet concerns a matter of public interest, then it's within their legislative duties for sovereign immunity purpose. That's how they'd already satisfied in their minds how to deal with my I was able to frame the issue. He who defines the terms wins the debate. But my brother taught me when I was a kid. And I wanted to define this as, is there a limitless license to lie if you get elected to Congress? And that framing worked well enough to force them off of embracing that position because the district court actually did really kind of embrace that position. He didn't put any limits on what would be outside their duty.
I recall he said if it was only incidentally related to the work, then sovereign immunity applied, and it was incidentally related to, and therefore, I mean, it was shockingly broad. I just rewatched my original video on it. It was shockingly broad the way he dismissed it.
Yes.
And it is. I very much, and everyone should appreciate the beauty of. You want to talk about a catchphrase that sticks. Is election to Congress a license to lie? It's a little more than 3 words, but that is it. That is the take it or leave it summary. Is
yes,
everything they say. The other thing is anything they say can be tangentially, incidentally related to a matter of public policy, a matter of public interest, and therefore justified. There's very little that anybody says that everything is politics. You know, what you eat for dinner could be a matter of public interest. And so it's almost impossible to escape it on that level, which is where I was concerned is the Court of Appeal is going to go. So,
yeah, I think that. So once I realized that's where they were going because they paralleled the questioning, then I realized, okay, so that's the main issue we have to address. But I was happy because I was like, all right, so at least we're going to get some limits. So I was like, at least we're going to have a partial success here, even if it's not the full scale success. We're going to change policy in America in a way that high-ranking lawyers said could not happen. So that by itself, I was like, all right, we're halfway home. And I'd like to get all the way home, but it's great that we're getting halfway home.
Because one way or another, and I think people are going to appreciate this, there's going to be a written decision. It's not going to be rendered orally. They are going to say in the written decision, there is a limit, although this case isn't that limit, in which case that's going to be an appeal precedent for the future to change policy or hold politicians accountable. What that limit's going to be.
And it'll be the first case ever to do it. Since the Westfall Act was passed, and it was something that high-ranking lawyers said was impossible to do, and it was frivolous to even think you could do it. So I like it, and my clients wanted, hey, at least establish some change, even if we don't get everything we want. Make it harder, make it so that it's possible to sue these people in the future, and so it'll be a fact-dependent inquiry in the future. And we're going to get that. We're going to get some form of that. Now, once the judge went to that line of questioning, the biggest mistake the other side made, in my view, was they did not have definable limits easily set up for them. The judges those two were trying to lead them into saying, hey, tell me why, if we limit it to questions of public interest, we're okay. And instead, they really didn't. They were like, there's definitely should be limits, but let's just not apply them here. You know, yeah. I get it. I mean, I've sometimes been in that position where there's nothing I can do to give a manageable. But you judges want a clear guidance that they can copy your words into the text of the decision, so they can feel comfortable that you've vetted it, you've researched it as the advocate, and you're giving something that's manageable that they listen to. They say, "Oh, I can work with that." They didn't. Neither one of them gave that to them.
Well, also as a matter of forcing a concession of intellectual honesty, to say, okay, you acknowledge there has to be a limit. Give me one example where you could. And if you say, well, there has to be, but this isn't it, and you sort of weasel out of giving the answer, it doesn't look, I mean, it looks like it's lacking credibility to some extent, or lacking total intellectual honesty.
Correct. And nothing it's nothing manageable that's too vague and too broad, so that they want something that they can give instruction on to lower courts so that lower courts know how to apply it. And they didn't get that from the other side. And then the other utilities, here's where, because I knew the two judges I needed to work with were Democratic judges, I seized the opportunity that they afforded by the Buffalo comparison. So the utility to that comparison, I thought they were going to go with George Floyd. I tried to cut that off early by saying, well, there's federal legislation before they even talked about Floyd, because I thought that would be where I would go if I was the other side. I would say, yes, you could comment on Floyd, but say maybe not this case over here that's not high profile, et cetera. But instead they brought up Buffalo, which was nice because there's two Democratic judges there. So it afforded me an opportunity to say, you don't want to give Trump immunity here, right? So I get to say, to draw the limitation, you got to hold Trump, in order to hold Trump responsible, you're going to have to hold Warren responsible. And so that was perfectly set up. And I could tell I could see the judges. Because it was a Zoom conference, whereas other people cannot, they don't allow that to be published. But their facial demeanor and disposition, particularly of the judge who was asking the question about the Buffalo case, was such that she seemed truly conflicted. And she was like, okay, maybe this is a workable standard of if it's in the public interest, but maybe that doesn't even mean anything in the end. Maybe it ends up devolving into the same thing. And once she was acting that way, I realized, oh, that's an opening. And she's probably not on the pro-Trump side. One, she fits the demographic of hating Trump, professional class woman over 45 with a postgraduate degree. But also, given originally a Clinton appointee, she, by the way, her whole life has been on the bench. So, she came out of it. So she went out of law, graduated high out of Penn, went to work, clerked at the Michigan Supreme Court, ended up marrying the justice she clerked for. Then went and ran for election as a state court judge just a couple of years later, and then got elected to the Court of Appeals, and then I think the Michigan State Supreme Court, if I recall correctly, then was nominated twice for the federal Sixth Circuit Court of Appeals, getting it in 2008, 11 years ago. So she's a practical judge. She's a judge. She wants to be able to go home, sit at the dinner table, and explain to her kids why this was a manageable and fair standard. And if it doesn't work like that, I think the older African-American judge, the lead chief judge, he convinced her initially that that was a manageable standard. And I think he'd even convinced her to say, look, if we limit, like the last question he asked to me, he was like, look, under your standard, all they got to do is put a bill in Congress that justifies them. When that wasn't, of course, my standard, really. I had a different opinion. So it afforded me an opportunity to go along the explication about how his own argument means he should go with me rather than the other side. But which he was a little bit surprised by. That's why there was no follow-ups. He thought he was going to have a couple of hits, and he's like, oh, okay, never mind. The other thing I always tell lawyers, wrap up. Like, just because you're a lawyer doesn't mean you have to talk. If you finish good, closing argument, cross-examination, oral argument, wrap and sit down. Just because you got 2 minutes left on the clock doesn't mean you have to use the 2 minutes, because I've far more often seen that go sideways and south than good. When you got a good rally, stick with the rally, because that's what sticks in their head. Just like first impressions, last impressions. And so by the end of it, I was like, hey, I went into this thinking 25-75. Most people who had looked at this thought I had less than 5% chance. And I was like, man, it's better than 50-50. I get at least half of a win. I at least get them to say it's not a license to lie. They have to be doing X. It's going to be some limitation. Maybe it's public interest. Maybe it's high profile public event. Maybe it's a response to somebody's question. In other words, a fair standard would be if you are responding, if the only reason you made your statement is because you're an elected official, because of something about the questioning. And that's what all the other cases really describe. They describe someone that almost has to make a statement because they're a public official. The statement never would have been made if they had not been. Then that would make more sense. But that's going to end up the speech and immunity clause, the parliamentary privilege logic that goes to Australia and Canada and the United Kingdom. This has been developed over 400 years. There's a reason we have those standards. And it became, they ended up deciding the best way to do it was to say, if it's in the hall, okay. If it's outside of the hall, no. Because anything else, politicians are going to figure out a way to weasel around it. And it's going to look bad, because it's like, hold on a second. If I'm a congressman, I can libel you, but you can't libel me. How does that work? And that's why I think also, no matter what they do, it's going to go up to the Supremes. I think they're so motivated on the other side that they think this is Congress. What was interesting is when I brought the suit, one of the reasons I brought it is I realized that all these lawyer statements on TV saying, Barnes has no claim. I was like, oh, that means all these Congress members really think they have a license to libel. And that would explain why they're so aggressive. That's why they were so aggressive in this case. And I was like, well, that means I got to bring suit just to try to put a scare into them, if nothing else, to think twice about it. But the fact that we're going to get any part of a win is critical. But I think they'll take it up to the U.S. Supreme Court. If we are unsuccessful, we'll take it up to the U.S. Supreme Court. And this is a great U.S. Supreme Court issue. Yeah. It's clean, it's neat, it's high profile, and I like my chances there too. So I think one way or the other, we're going to win more than everybody said I could. We may not get the full prize, but we'll get something meaningful that changes people's lives moving forward.
Amazing. I'm going to get these super chats before I get into the Trump tweet, because I found that part to be very interesting as well. VA Philly fan 54 says, question for RB, is the definite or defining argument that AG opinion is irrelevant due to congressional immunity, and plaintiff argues AG should weigh in on scope of duty? Maybe don't answer this.
It was part of my argument. I brought it up briefly because it wasn't the big issue for them. Also, I honestly didn't necessarily want to get them an easy way out. I didn't want them to say, oh, you know what? The attorney general should have certified. Let's remand and see what the attorney general is going to do, and then you can come back up. I wanted them to make a clean ruling one way or the other. Where is the limit on immunity? Where does it apply? And make it clear, make it in such a way that at least we've changed the law on that, or have created a good argument for legislative change or Supreme Court adjudication. So their argument is that it was that they didn't have to seek it, so it ultimately didn't bear on the decision. They're right; they didn't have to seek it, but what it is. It's a reminder to the court. The best argument is not so much a legal one. It's not a binding requirement that they seek the Attorney General certification. There's never been an interpretation of that issue because they've always sought it passed. But what it really does is it tells the court, obviously, we all know this was not part of their official duties. That's what it really means, because that's why the Attorney General is not stepping in, and that's why they didn't seek it.
Okay, amazing. Now I just missed one. Vicky Rose, I can't bring it up, but it's Vicky Rose, thank you, says, warn counsel trying to say that if something is of public interest, it warrants constituents, then give her immunity. I mean, basically, that was one of the arguments, which was anything of public interest is official duties, and we'll see if that's the threshold. It'll be an interesting threshold. I missed Joshua Cornelius's, and I can't even see it on my computer. I'm going to read it off my phone. Obviously, this case is not about monetary satisfaction. How likely is this case to inspire real legislative change to hold politicians accountable for defamation? The establishment does not cede power lightly. Joshua Cornelius, thank you very much.
It depends on how much notoriety it gets, but there's almost no, my view is if they come down with a decision, they're going to come down with a decision before Election Day, probably before, my guess is sometime this summer. And so even before them, I'm already talking to Congressman Massey's staff and other people about doing something about this. And I'll find a congressman who will back it. Or a senator who will back it. And then it becomes an issue in every congressional member's campaign, potentially. Say, do you think getting elected to Congress means you have a license to lie about the rest of us? And who could answer yes to that? Almost every congressman's going to have to sign on to saying they're going to pass the bill that takes away their immunity. Now, does that mean it will happen? No, it doesn't. But it gives us the best chance of it ever happening will be this case.
And if you get to the SCOTUS with this, it'll be phenomenal. It'll be phenomenally interesting because, and I want to get to the Trump tweet. I'm just going to read these two first, but it gets to Trump as well, because it was interesting. You took a position ostensibly adverse to Trump's tweet about the Buffalo guy and the allegations made in that tweet, which many people took issue with. I think it was the first time Trump got ratioed on one of his tweets on Twitter. But it's an interesting thing is people want, and people have been complaining about it forever, is that they hold a standard to Trump tweets that they don't hold to other politicians' tweets, and to not conflate, but rather to merge those issues before the Court of Appeal, where they could say, this is how I feel about Trump's tweets. And so I therefore have to feel the same way about other politicians' tweets. It's an amazing way of phrasing the question, and also presenting yourself as an ally to the two judges who you think would be against you, as opposed to an adversary. It was phenomenal. If anybody hadn't seen that part or listened to that part of the audio, check it out. Kanan Buckingham says, my new favorite channel. I don't miss a video with you and Barnes. Keep up the amazing work. Robert and I are in discussion as to whether or not we start a separate channel where we just do this once a week, and it would be easy to convert into a podcast. It's if Robert's game, and I'm not saying this to him for the first time to put him on the spot. We've been talking about it. I feel obligated to separate this from my main channel, and Robert and I do this independently. So we'll see. There might be some stuff in the works in the longer run. I missed something here. I know I missed a bunch of stuff. How does this happen? It happens so quickly. We'll get to the odds, the likelihood of success. Unfair to keep Barnes Esquire in cigars and neglect Viva's poutine budget. Thank you very much, Beef Noel. Yeah, I haven't gone for poutine yet. The stores have to open up, full time as of next week. How much does a Zoom conference change the game? Do you prefer to be in the courtroom? It's an interesting question, actually. Let's get
mixed sentiment on it. The utility to the Zoom conferencing is you can have all the pleadings around you if you want, and you can just grab whatever you need when the other side is arguing. You can pull stuff off of your computer if you need. So you have easier access to more information without having to physically carry all that into the court. Now, for me, that doesn't make a big difference, because the way I approach oral argument is I try to memorize citations and quotations from a range of cases in the factual record. Been doing this since I was a kid, because it's sort of it's a very effective persuasive argument if you're able to recall from memory right while you're talking to him, looking at him in the eye. And I could replicate this with the Zoom conference as much as it's a little more impressive in person, because everybody else walks into the courtroom, the appellate court arguments, they usually have these huge books, and they carry these huge books. They put them down at the table with all their big stuff, and then they carry a whole book all the way up to make the argument. I walk in with nothing. I have a piece of paper in my suit pocket, and sometimes I'll take it out because I got all these little notes on just one piece of paper, put it down, but it always throws them off. And they're and so they're tempted to try to ask a very like, hey, well, what about what was the fact pattern of some like 1 out of 23 cases you cited, or say, challenge, and I'm ready for all of those. And I do it right on the top of it. And then they're like, well, okay, I'm not going to challenge this guy on what the prior, skip on. So it's a tool. So I don't get to, it's not quite as effective on Zoom because for all they know, I'm looking at some, script over here. Like the poor guy for Halland was doing. I mean, you could even hear it. It was worse visually. That poor guy, he was like, duh, 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 duh. I was like, come on, you got to at least pretend you're not reading, my man. But yeah, he was nervous. I don't begrudge that. When I was a kid lawyer, it would have been scary. So and particularly, I have a record. I one of the highest success rate in appeal, difficult appeals, especially of any lawyer in the country. So I often run into other lawyers who will get like much more nervous and jittery. So I'm not critical of them for that. That's being smart, really. They understand that this is different than the normal game. And so, but yeah, so I personally, I prefer Zoom for depositions because then the witness can't see what it is I'm looking at. I like that because then I can pull different stuff, grab stuff over here. They don't know where I'm going. I like that. I like Zoom better for depositions, a little less so for oral argument for appeals. Though if I'm going to get screwed, I much prefer Zoom because it's like I don't want to travel all the way there, spend a day there, a day travel there, 2-3 days. If the judge is just going to shaft me anyway, that's probably going to happen to me in this case in Virginia coming up, where judge is making me personally appear. It's Alexandria, so you got to fly one place, drive another place, and he's probably going to shaft me anyhow. He just wants to shaft me in person, so I'm afraid. So I hope not, but those are the ones. But otherwise, I prefer in person because there's a certain in-person communication, especially when you really know the facts and law well. If you've taught yourself, practiced, and prepared well, then it's great. If you haven't prepared well, then Zoom is almost always better because you can grab something there without them knowing it.
I find Zoom is great. In person is always better. And I always find the technical aspects of Zoom, when the judges have a question, there is the audio overlap. I don't know if you guys hear the noise coming from upstairs, but there's audio overlap. There's, the lawyer at one point was talking and nobody could hear him. And, it's not ideal. In person is always better. And especially when you have an aura.
Also, for all these judges, I see a lot. I bet I've done a bunch of these Zoom conferences now with judges, so I'm not specifying any one judge in any one proceeding. No one can infer that. Let's just say there's a reason they're not recording. They're more casual than they would look normally. Let's put it that way. So I was like, that's interesting. So I think that now they're more relaxed for that reason. The impression I get is it's been interesting. They have less access to their clerks like they do in the courtroom. So I think they're almost more transparent, whereas sometimes with the clerks are feeding them specific questions. And so it's almost ends up being more of a little bit of a theater than it is them giving away where they're going or where the core issues really are. So that side of Zoom I like better. I think I get a little bit more transparent judge when it's by Zoom than I do in person in the courtroom, interestingly enough.
Amazing. Jason McConnell says podcast name suggestion Fried by Barnes. Interesting. Okay, no, I don't think there's anything more to get out of this. I mean, it's phenomenally interesting. I understand now this. I can understand. I won't call it spin. The framing that this is a win-win in the sense that even I, acknowledge when I'm listening to that audio and I hear the lawyer say from the other side there have to be limits. This just isn't the case. I can see the Court of Appeal, giving you reversing the decision and saying, look, they'll have the right to do this later, move to discovery and see if the facts support a sovereign immunity defense at that point. But this was way too preliminary to dismiss the case on that basis. I could see that happening more likely than not. And that would be, first of all, from a case perspective, strategically for you in this case, it would be great. And from a policy perspective in the long run, precedent, it would be great.
Yeah, it's the reason I took the case. I took the case in part to make new law against some of the other people. Because I'm doing the whole case pro bono for free. Nobody's kicking in. I know there's some questions or comments on the video feed thinking maybe there's some secret funder. There's no secret funder. It's coming out of my own pocket for cost and stuff. The Free America Law Center that I helped start is help funding pay some costs, local counsel, stuff like that. But it hasn't even kept up with that. That's just the reality of it because the local lawyer costs money, and then all the service of process because of multiple people, and some people not helping with service of process, let's put it that way, made it a little more expensive. But for me, the reason to take the case aside, I wanted to help these kids. I promised I would, so I was going to do it anyhow. But was the public policy reason was to change the law to help and it's what all these parents wanted. They weren't looking for fame or fortune. They were looking for let's make it harder for people to do this in the future, like what they did to my kid. And I felt I was well equipped to help create that reality. And so for me, the public policy outcome matters more really than the technical outcome. If we got an outcome where they settled in secret and got no change in the law, I would not take the case for that purpose. That's not what I was out for. I wanted public policy change, which can only happen with written decisions. And Senator Warren has turns out to have been very helpful in that regard.
Amazing. I think we're going to move on to the FLynn now, because I think we've got everything out of this. Just going to read this. Honestly, you like the button. This is VA Philly fan 54. I know we got Jason now says 2 lawyers, 1 case. The implications of that title would be far beyond what would be acceptable for a podcast. If only, okay, we got it. Okay, then a bunch of things just blew up here. Let's do this before we go on. Mandatory care. Oh, we got, okay. Does Robert Barnes only do law? What does he do after work, if there is such a thing for him?
So yeah, I mean, other than some podcasts looking at communication, right now doing the American Countdown show, which is shifting to become a podcast throughout the summer, so it's a little less intensive than doing it live every night. But yeah, sports, cigars, film, travel. That's the amenities outside of law and politics. Betting on elections too.
Oh, speaking of which, given the odds, I know I have to place a bet. I need to find a Canadian betting site that allows me to do it. The odds don't make sense in my mind, or at least are susceptible of change in a manner that would be profitable in the immediate term. Mandatory Carrie says at work, but keep fighting. Thank you, Mandatory. Real Bambunga. I'm not going to read the comment, but thank you very much for the chat.
Yeah, it was interesting. Is there was nobody reacted. So I was fascinated by that, watching him. He made that statement with a straight face, but you also notice none of them picked up on that. None of them. So the judges weren't going down that path. They recognized the implicit comedy component. So that's why they only talked about build the wall. They didn't say, let's not talk about Senator Warren's Native American special connection. Yeah, there's
it's the elephant in the room, but everybody knows it's there. How does Robert think OJ was innocent, though? Coming. That might be a good inaugural stream for the new channel.
Yes.
Mark Hargis says, Viva, Frei, thanks for doing the live streams earlier. It helps me with my sleep. I've had much love from Nouvelle Orleans, New Orleans. Keep kicking butt and taking names, Mr. Barnes. Thank you very much, by the way. And Joshua Cornelius, if there's a way to donate to the Help Fund Barnes pro bono work, is there a way to donate?
Yeah, the Free America Law Center does help pay for all the cost of this. So I've been fronting some of those costs, and they reimburse it. So I help start the organization. I don't run the organization; other people do, but they do good work. So you can go to freeamericalawcenter.com. And you can become a monthly subscriber or just make whatever donation you want as a one-time thing. So that's where people can help support the Covington case and a bunch of other pro bono cases. About 25% of my work is usually pro bono. Last year, it was higher than that. So there's some people that work for me that wanted to get a little bit in balance. But any help people do is great.
And I'm going to link those in the pinned comment, as I've done with the last few streams, I hope. Okay, let's get into it. I know people want it, and I hear kids are going to be coming sooner than later. The Michael Flynn situation. I think some people might be a little, not confused, but it might be difficult to appreciate what the Court of Appeal was adjudicating on in the context of the brief coming from the amicus the same week. The Court of Appeal strictly adjudicating on Michael Flynn's petition for writ of mandamus, which would be to order Sullivan to grant the Department of Justice's motion to dismiss. Nothing else, correct?
Yep, and close the case.
And Sullivan, we order you to do it. Would they order Sullivan to grant the dismissal, or would they grant the dismissal as though Sullivan should have, thus closing the case? Like, is it giving it back to him just for the technicality?
It's still giving it back to him. The other thing they could do is they could say, we remand this to the district court. We grant the writ of mandamus. We order that Judge Sullivan be substituted in for another judge be substituted in, and we order that judge to dismiss the case. So that's the other option they have.
Okay.
But either way, they themselves can't dismiss. It has to happen at the district court level.
Okay, and now having listened, I didn't listen to the whole hearing in that. I listened to some of it.
An hour and 47 minutes. That was crazy.
That's still nothing. I just couldn't. I mean, I say nothing compared to how things get off the rails in Quebec courts. I mean, that's still
really interesting. I mean, for people that are watching, that's almost unheard of. That's one of the longest oral arguments in history.
It's amazing.
In America.
One thing I heard, which made me concerned as to what the outcome was going to be, is they were repeating the July 16th hearing date on Sullivan's motion, as if to suggest, why would we do this now when in less than 3 weeks' time we're going to know what Sullivan does for right or for wrong, so let's just let him go ahead and do that. Am I off base there?
Yeah, so you have another sort of unusual dynamic in that case, because you got 3 judges, one Obama judge, one Trump judge, and then one Reagan District Court appointee, but Poppy Bush appellate appointee. I didn't realize that the Poppy Bush part. Had I known that, I thought she was a Reagan appointee, and so I thought she was going to be real strong and aggressive. When I found out she was a Poppy Bush appointee, I was like, oh, she's going to want some institutional compromise. Because your Poppy Bush, it's weird. In the United States, if you tell me which president nominated that person to the bench, with about 80-85% accuracy, I can tell you their philosophical approach to cases and their psychological makeup for trials if they're a trial court judge. It is extraordinary. Now, it kind of makes sense that a president would look for someone like themselves, personality-wise, philosophically, and who they appoint to the bench. But given how judicial appointments work, where presidents almost never meet them typically for lower court levels, it is striking how it's turned out that way. But it is really predictable. I started using it as a tool when I realized how predictive it was. So once you know she's a Poppy Bush appointee to the appellate bench, then that means that typically those Poppy Bush appointees are the most, they're like Roberts. Though Roberts was a W guy. They're like, can't we, let the institutions work this out and figure this out? Should we really be jumping to get involved if we don't have to get involved? Like he did in the church case about the lockdown. It's that same mentality. And so, but even more intensified, because Poppy Bush appointees were worse at that, or more like that, whether you like it or not, than W appointees were. So I think that's one. So it was amazing how predictable. The Trump judge was highly skeptical of the government. It's clearly going to say the writ should be issued. The Obama judge was highly skeptical of, I should say, the Trump judge was highly skeptical of Sullivan. Then the Obama appointee, of course, was highly praiseworthy of Sullivan. So you know that that judge is going to say no to a writ issuing. So it's going to clearly come down to the Poppy Bush appointee. And while most of the time it sounded like she was saying, hey, it's a little early to issue something extraordinary like a writ when we haven't even given Sullivan the time to actually say whether he's going to make any of these purported risks come true. But she may have given herself away at the end, because all those institutional judges are particularly, like Roberts, deferential to the executive branch. And when she saw how aggressive the government was at the end, saying, hey, judge, here's the debacle we're going to face. And we're going to face having to answer things that this is going to be a political nightmare. It's going to be a political storm. This is going to be a war between the judicial branch and the executive branch. Once he made that clear, she asked her last question, which was, maybe the government should be given a chance to self-correct. And maybe that's what all this really is. And that suggested that she was going to issue the writ. Or if she didn't, she was going to couch it with language that said, I'm sure Judge Sullivan's going to dismiss and not do anything else crazy. Let Sullivan know if you go a step off, I'm going to come back in and whack you, but I'll give you a chance not to be embarrassed. But I'm banking that she actually issues the writ because of what she said at the very end. And now the real reason I'm banking on it is for what they didn't discuss at all. The only area where I'd disagree with Sidney Powell is I would have framed the issue like Covington. I'd have come in and say, do we want to give judges the green light to become practical prosecutors and appoint their own special counsel like it's Europe? Because if you let this go on one more day, that's the reality. This isn't about whether he dismissed or not. This is about him acting like he's a Spanish-style inquisitor with the powers of the Inquisition, with the powers to do with subpoenas, the power to do everything else. And we shouldn't have to wait to see how crazy it gets before we stop this from getting crazy in the first place. Because if not, every judge in America is watching this, and every judge has their own feelings about cases, and every judge in America is going to start picking up their pen and saying, I'd like to be prosecutor too. So I think that's lurking in the back of their mind. And that's the great for an institutional judge, like the main judge is going to make the decision. I think for her, that argument would be particularly persuasive. And I think she's still thinking about that, even if they didn't discuss it, because she doesn't want what Sullivan did to get out of hand. What she would prefer is for Sullivan to correct it on his own accord. But she isn't willing to gamble that Sullivan won't do that quickly. So I think that's why likely grants the writ. But if she doesn't, it will be written in such a way that Sullivan should get the message. But I think where she's wrong is Sullivan is more arrogant than he is competent.
It's very interesting. There was one thing I was just about to ask before I lost my train of thought, which was, oh yeah, that's right. I'm sorry. The amicus filing his brief before the hearing, before the Court of Appeal. There's an economic cynic in me that says, if this is going to get dismissed, the lawyer wants to do his work and get paid for it. That would be like the most, superficial level of cynicism. The deeper level of cynicism is the judge realizes now, the amicus realizes now, I got to file my brief to give all of the arguments now, not just to Sullivan to dismiss, but rather to the Court of Appeal to dismiss the writ so that Sullivan can then deal with it. Did he file that to influence, or is it wrong to think that he filed it so that the Court of Appeal would take cognizance of it before the hearing?
I think it's a third reason. I have no doubt he filed it because of the timing of the hearing, because he was not on calendar to do that at the time he filed it. But it may be a third reason, which is he thinks the writ's going to be granted, and he wants to preserve for the record what a horrendous action the government's action was. He wants to be part of the judicial record for posterity and the rest. So I think it was all three. I think it was partially for posterity that, hey, if they're going to grant the writ, at least I got my 2 cents in, and it's part of the judicial record that anybody can see. Second, I'm getting it in before they make a decision, so at least the Obama judge on the panel can see where I'm going and why it's important we go this way. And then third, I think for certain parts of PR and other purposes did it. I don't think economics would be a factor for him, given the amount of money he makes at the firm he's at. I think politics would be, but I do think the timing was no doubt he intended to get it in before. And now I think it backfired, because if you read that, once they knew who the panel was, and they knew that before he sent in his opinion, once I was reading that, I was like, okay, if I was him, I wouldn't file anything, because clearly the deciding judge is going to be a Poppy Bush appointee. And given that institutional person, I would not want to rock the boat and make it look like, hey, maybe nothing will happen. Instead, he made it clear just how inflammatory and political he was by what he wrote. He antagonized a bunch of people on that, even what I would call moderate right people, moderate types. People, your Jonathan Turley types, were like, this is a horrendous, there's all kinds of problems. All your defense lawyers, the few who can get past their hatred of Trump, were like, hold on a second. I could never withdraw a plea under these standards. My client would always be threatened with criminal perjury. This is nuts. It's going to be part of the sentencing now? That's nuts. So I think those aspects of it backfired. I think he thought he was helping himself. He did not read his audience. If there were 2 Obama judges on the panel, then yeah, do what he's doing so they get the message, hey, this is why we need to let this go forward. But he didn't have that. Instead, he had an institutional judge. And I put it this way, if she issues an opinion that grants the writ, it'll be because he made the mistake of issuing that inflammatory amicus brief before the hearing. Because that's where she's like, well, it looks like the institutions just won't cure this. So it's sort of like in Attorney General Barr's mindset, I'm going to have to stop it from happening moving forward, even though she hates looking like she's undermining district courts and hates going against Sullivan, whom she has a personal relationship with going back many years.
Okay, that's amazing. Let me see if I can get these. I think a lot of them are going to have disappeared. Doesn't the JD requirement and the bar just make lawyer-judge relationship a buddy cop show?
Sometimes it hasn't in my case, but there are some that are. I've had plenty of judges threaten to throw me in jail and prison and other nice fun things. So but it's a problem. The biggest problem is that the Supreme Court, the courts control your licensure, and as long as that happens, then lawyers are put in a very difficult position of not being able to be independent, because if they raise questions of judicial integrity, then they will be they have a risk of losing their licenses and their professions and their occupations. So I have been a lone wolf or lone voice in the wilderness on this in front of courts, because I'm telling courts, hey, here's why you shouldn't have all this power. What court wants to hear why they shouldn't have power? It's not, but logically it's a problem. If the executive branch should enforce our licensing requirements, the legislative branch should draft them, and the judicial branch should just adjudicate them. The judicial branch should not be drafting the rules, writing the rules, enforcing the rules, and interpreting the rules. That just makes it difficult and allows judges with questionable behavior patterns to stay in the reason why corrupt judges hang around longer than they should. Just like there's 10% of cops that are bad, there's going to be 10%. Like 10% of protesters can become rioters. 10% of judges can be bad, but they're not exposed in a timely manner because the legal profession is told that they may face personal professional consequence if they report it.
Okay, we got, with respect to FLynn, is it normal for a plea deal to include a not allowed to get exculpatory evidence provision? If so, scary.
The government likes to include that. My view is it's unconstitutional to require it. Because Brady's a due process requirement. It's an obligation on the government to give him not only exculpatory information that could help him at trial, but could help him with the sentencing, could help him. Also, how can you ever plead if you don't know what evidence could help you at trial? You cannot make an informed judgment about whether you should accept a plea if you don't know what evidence could help you at trial. It's impossible. So in my view, you could never have a knowing, informed plea that denies you exculpatory evidence. Now, a lot of courts have been turning a blind eye to this, but that's what the law should be. And now and then they acknowledge that. They just don't enforce it on a regular basis.
Okay, and I totally agree. It's like you're giving up a right that in advance before it is even born that you don't know exists. It's not something that anybody can do. Ian makes this, have you looked at the judge's decision in the U.S. soccer team wages? An interesting 32-page document. I've looked into it. It's interesting. Nate Brody did a great video on it, so you can check that out. I didn't think I had much to add. It was interesting. Sir Barnes Esquire, are the books behind you, or are there books behind you, or are you in a colonial palisade?
So I got a legal background. So if it's good enough for legal, I figured I could do it. So it's a fun green screen. It's a fun. I put all kinds of things back there.
It is clearly a green screen for anybody who can, you could see it around the the contours of the headphones is the giveaway.
Yes.
Thoughts on Judge Wilkins' inflammatory example of excessive force by police officer?
Yeah, that was being political. That's how all the Obama judges are, though. They're all real political. Now, the only thing I would have done, it's a little bit risky because you got an institutional judge you don't want to offend there. But put it this way, if there were 2 Obama judges on there or 2 Trump and Obama judges, if I did not have an institutional judge there, then I would use a counterexample when I'm given those. Because sometimes I'll be given an example like that. Look at this. Doesn't this show how bad your case is? So I find the example that makes their argument look bad and say, well, let's look at it from this perspective. So that was the utility when the judge opened the door about legislation. Say, yeah, you're right, Judge. Imagine if they start writing legislation that says, hey, by the way, I'm now immune from my own crimes. Is that okay? None of them want to admit that. And then it's like, well, at some point, then you have to acknowledge limits have to be drawn. And the only question is where? Well, where's manageable? I thought that was a very inflammatory line of questioning from the Obama judge, but that's how almost every Obama judge I've dealt with is. They're very political, they're results oriented, and they're very rhetorical, and they're aggressively rhetorical. And you have to throw that right back at them to make them think, well, hold on a second. Obama was that way. When Obama was challenged in a certain way, he didn't rise to the challenge, he would recede. A lot of his judges appointees are the same way. So you just have to be very smart and very strong and very prepared. And if you are, you can back them off of that kind of preposterous hypothetical. But the reason why I think the government was cautious is because their whole goal was that judge is gone. I want the institutional judge to like me so I won't be aggressive and too polemical.
Okay, interesting. We got Tori Pittman says, why no Alford-style plea for federal cases? What is an Alford-style plea?
Yes, you can do an Alford plea in federal cases. They probably would not have allowed that as part of this plea deal. But an Alford plea is United States versus Alford. I believe it's a federal case. It might have been a North Carolina state case, but I thought it was a federal case. It's what the West Memphis 3 ended up doing. It's where you accept a guilty verdict by agreeing that you cannot contest the case and win at trial without ever saying you're guilty. So its biggest impact theoretically can be certain kinds of admissions for. So theoretically, you could do an Alford plea and that would remove the risk of perjury. the perjury charge. The perjury charge always was a bogus claim by the judge anyway. Criminal contempt doesn't allow perjury charges most of the time, unless you have an obstructive component. But that's theoretically what it does. Otherwise, its most biggest utility is civil liability, but it doesn't really quite work that way. So, even if you have not pled guilty, once you are found guilty, it acts as res judicata or collateral estoppel anyhow. So it's actually, I was part of a law research project in law school that argued that Alford pleas really don't do anything except make a defendant feel better. There's no clear legal benefit to it. But it's government prosecutors almost never allow it, and judges hate it and will usually sentence you to a higher sentence and deny you acceptance of responsibility, et cetera, credits that you get that could reduce your sentence if you do an Alford plea. So it's very rare. But it did happen in the West Memphis 3 case because they knew they were innocent, but they didn't want them to be able to sue them.
Okay, amazing. Robert and Viva, you truly make me interested in the machinations of the law and like a couple of lawyers. LOL, keep up the great work. Charles McCollum, thank you very much. I forgot my question now. Let me see if it comes after this one. Will Trump judicial appointees also be as predictable in future cases? So far, they are. So far, they're pretty strong. The judge in the Covington case, for example, asked the most questions of both sides. And so, though I thought his sensibility was, I thought he was the most likely to be with us. So, for the most part, they have a weird way of reflecting the personality of Trump. So, but some of them, particularly his appellate judges, tend to be very intellectual. His district court judges, not always. I had a Trump appointee that told me he got his facts from the internet. So, it is what it is both ways. Okay, the question that I wanted to ask about the brief, the amicus's brief, and incidentally, like the whole position, Sullivan's position as well, although he shouldn't have a position. How do you get through that entire brief without actually, specifically addressing how damaging those FBI notes were and how damaging the fact that, the emails disclosed that they might have threatened Flynn's son? How do you avoid discussing that and retain credibility before the court? It's clearly what Sullivan wanted, in my view. I think that's what he thought he was giving him. And it shows you how judges handle information that they can't explain, is that they simply don't discuss it. And that's a sign of the strength of their argument. By the way, it was credit to the government. They concluded really strong because before he went to look at all the disaster that this would create, so forth, he also emphasized to the judge that triggered that judge's last question that sounded like she was going to give him a writ was, look, everybody acknowledges that what the FBI interview did was deeply problematic. And they're saying nobody's disputing that. You're not going to find that in the amicus briefs. You're not going to find in anyone else's briefs. So I was reminding everybody we're really here because the government did a lot of nasty stuff. And they can pretend otherwise, but we all know it. And so he saved part of his best arguments for the end, which was effective, I thought, particularly with such a long oral argument like that one was. A typical oral argument for people at home is 30 minutes, between 20 and 30 minutes, 10 minutes each side, maybe 15 minutes each side. So when you see hour and 47, that's totally, incredibly rare. Even the U.S. Supreme Court's usually only 30 minutes, sometimes an hour. So it's never really this long. They have too many cases for it to be that long. So it showed how significant it was, substantial it was. I thought the amicus undermined his argument badly. He came across as polemical. He came across as political. He didn't honestly address key questions. Like if I had been in his position, even if I had his political agenda, I would have written it differently. I would have written it like, hey, you know what? Maybe there's some issues of government misconduct to really go into that because they're dismissing the case against General Flynn. Maybe there's some government misconduct that will stay hidden that really shouldn't stay hidden, that would have come out at a trial. Make it sound like you're being fair and balanced and you just want to get to the bottom of government misconduct. Don't make it sound like a political hit job where you pretend your bad facts just don't exist. Ask any lawyer. That's almost never a good strategy unless the judge is in your pocket. And here, since he was really writing for a different audience, he wasn't writing for Sullivan. No, a lot of people are going to say, not only was is Sullivan in his pocket, they're both in each other's pocket. Sullivan appointed this guy to, draft what I want, what I want to hear. And he did it. And it's just, I just don't know who can read that brief. It's not a question of, being partisan or being biased. It's that there are obvious deficiencies. You can't just refer to the 4 additional emails, that they discovered, one of which was threatening to prosecute his son, failing a plea bargain, and the other one didn't even mention in the amicus was about the intent or the ostensible intent to frame, and then just to mention the day of the filing of the motion to dismiss that one of the prosecutors withdrew from the case without explaining why that might have been or why that was. It is superficial glossing over of devastating facts to a point that discredits any legitimacy in my mind. It's just a question of whether or not the Court of Appeal reads it and gets repulsed by it because, partisan politics aside, they should, or is partisan politics so deeply entrenched now in the judicial system that they're going to rely on those arguments to support their foregone conclusion. That was
my instinct is he made a major mistake, but we'll find out when they issue the opinion.
Okay, now we've got here. It says, what about Roberts in the church case saying that there would be a suicide pact? What? Yeah, that Supreme Court decision did not age well. I mean, Robert and I talked about it the last time. Okay, so hold on. Was there anything else? Let's see if I can do this. What were they threatening Flynn's son with?
A prosecution related to the Foreign Agency Registration Act because he did some work on the same project on behalf of Turkey. Though there was the most interesting amicus brief was by that other defendant from the case that the judge ended up dismissing because he said all those Turkish charges were bogus. Was by that lawyer, wrote an amicus brief to Judge Sullivan reminding him that the entire prosecution theory against him as the main witness the judge dismissed as bogus, which means there was never a legitimate legal basis to claim that either Flynn or his son committed any crime. It was purely it was a threat that that sounded impressive, but that if Flynn's counsel had been doing his job, would have said, no, there's no good grounds to do it. To give people some background, there are only 6 FARA cases, I think, that had ever been brought before these set of cases. This act has almost never been criminalized, and they've usually been reserved for unusual circumstances. So to be threatening Flynn's son, who was basically involved for like 6 months total, and in fact, it turned out everything was fully disclosed. It turned out it was actually businessmen, not the government directly funding it, but they disclosed the government was backing them anyway. So it turned out the whole Turkish angle was more bark than bite, as is reflected in the Northern District of Virginia case.
And a lot of people were rightly pointing out something I don't think I mentioned in any of the vlogs. I think you mentioned it, that the FARA papers, which were allegedly the basis for the untruthful statements, were filed by the former attorneys for Flynn. And so there might have been some sort of
there was a huge conflict. They had no business. I mean, if I've represented someone in an IRS tax matter and they're putting into question a tax structure that I did, I cannot defend that client in the criminal proceedings when there's that kind of conflict of interest, unless I'm saying there's nothing wrong and I'll back it up. But once they were saying maybe there's something wrong in the paperwork that we drafted for you, they had to say, there's a conflict now because it's in our interest to blame you. And it's in your interest to blame us. And so we have to step out. They just didn't want Flynn to ever think that far because he had no experience with the legal system. Guy's just been a general military guy his whole life.
And I do hope everybody appreciates that conflict, is that they were accusing him of having misrepresented, either lied on the FARA filings or misrepresented the content of the filings when the attorneys representing him against those accusations were the ones who drafted them and who were professionally on the hook, potentially. It's insidious. There's no other word for it. The question that I had 2 questions. Now, one that did I understand correctly that there has never been a refusal of a dismissal of charges under the Rule 48A?
Yeah. What Sidney Powell said was right. When she said, I don't understand, probably her best rhetorical point was toward the end where she said, I don't understand why General Flynn is the only one being treated this way when I can't find a single case in the country where any court has ever denied the motion to dismiss. And she's right. I know of no case. I'll put it this way. I know of no case, Sidney Powell knows of no case, but the telltale indicator that no such case exists is the fact that no one else cited it. I guarantee you if there was any case out there where they had ever denied the motion to dismiss, the other side would have been raising it over and over again. The fact that confirms that my research and her research is correct, that it's never happened.
And that could be a double-edged sword, is that if it never happens, they're going to use that as the argument for the fact that the judge doesn't, in fact, ever have the power to deny leave. But if the judge doesn't have the power to deny leave, then why did the law give him the authority him or her the authority to deny leave? So, I mean, I see that cutting both ways to some extent, that the law provides the discretion to the judge. So at some point, someone is going to exercise that discretion. And if they can never exercise that discretion, then the law says something for nothing.
I think the with leave of court was for a limited circumstance, that the judicial branch does not have to defer to the executive branch when the executive branch is misusing its prosecutorial power to harm a defendant. So, for example, let's say they're right on the eve of a bad hearing, or they're right on the eve of a bad jury outcome, and they say, hey, we'd like to come in and dismiss because what we're doing is we'll be allowed to go back and prosecute him next week for something similar, a parallel action. So the all of the legislative history is that that's what they were intending when they gave the leave of court language, was that if the executive branch is abusing its power, then that's what is being intended. And because it raises big constitutional questions if it goes past that. And it was the judicial branch protecting individual rights of a party to the case is one thing. The judicial branch having the right to replace the executive branch when both the executive branch and the defendant agree about dismissal is an entirely different thing.
And that was another thing. That was actually the part two of the question, where the amicus and, obviously the other side, not Sullivan's side, but rather the amicus side was arguing that this provision of law was created to prevent dismissing charges for highly politically connected individuals. Whereas, I had read, but I didn't fully understand that the flip side to that was that it was also that law was drafted to protect or prevent judicial harassment of the defendants.
Yes.
So it flesh out the judicial harassment side, because I understand in principle, but I don't understand how that materializes in fact.
Right. Exactly. The fear and the worry is when you don't really have a meaningful dispute between the parties, and when for some reason the judicial process, or I should say the criminal process, is being used for some impermissible purpose that really goes to jeopardizing either the executive branch or judicial branch's power, or is victimizing a defendant, whether the judicial branch or the executive branch is the one doing so. That's what the rule is in there for. So and that's what the rules are set up to do. And so, but the problem is your Obama type judges, even including some of your older Clinton era judges, see anything as a tool of power. So that they don't limit something to its original policy purpose. And so that's why you got the amicus that you got. That's someone who really believed in his own mind, hey, anytime I don't like what I'm doing, I don't like what's going on, this rule allows me to exercise that. That's not what it meant. But you can tell that's what he thought, and to some degree Sullivan thought. They don't understand it's there for a very limited circumstance or situation where somebody's individual rights are going wrong, or one of the branches is being deprived of their power constitutionally.
Okay, amazing. And I think we should wrap it up now anyhow, because I do. The silence is indicating that my wife needs me more than when there's noise. I'll just take these super chats. Drab, thank you very much. We got, can the city of Annapolis sue for putting them in danger by withdrawing the police? Very hard. Very, very hard. Okay. And there was another one, which I think I know the answer to in advance, just based on our previous streams. Are any of the lawyers, judges involved in Flynn's case in legal jeopardy as a result? I think it's a big fat no.
Nope. Yep. Big fat no.
Which is amazing. The conflict of interest part was what sort of struck me, because that, for someone who's very neurotic and nervous about these types of issues, I would avoid conflicts where they didn't even exist, but I might perceive a potential. Which
I would say one caveat with a dismissal. Flynn probably does have a legal malpractice, or at least right for refund of fee claims against the Covington law firm.
Okay, amazing. Okay, people, I think that's it. This is amazing. Robert, again, thank you very much. And I think based on the comments, there is keen interest in something. I don't want to create any more work for you, period, full stop. What we do, it has to be in your spare time, and then I will not create any more work for you, but we might, I think there's an interest in something dedicated, and it's great because this stuff you clarified for me. I'm certain you clarified for thousands of other people, and the more people that know this, it can only make things better in the world.
Well, exactly. As long as legal eagle exists, we're going to be like the Blues Brothers. We're on a mission from God.
And now, Jay Mill says, when is the appellate decision due? When is the appellate decision due?
On the writ of mandamus, it will be in the next 10 days in FLynn. On my case, there's no set schedule, probably within 3 months.
All right. 3 months is the codified limit within which to render a written decision?
No, there's none. So it can go over a year, go a year and a half. But normally within 3 months, they issue the opinion. But there's no required time frame.
That's interesting. In Quebec, at the very least, I'm pretty sure it's 6 months a rule, but nobody harasses the judge for not nobody wants to be the person harassing a judge to render the decision. Okay, people, I think we're gonna wind it up. This was phenomenal. Robert, again, thank you very much. Stick around afterwards. We'll talk. I'm gonna post your links in the pinned comment. I think that's it, and we'll see what the next subjects that develop over the next couple of weeks, because law, there's always something to talk about. Robert, thank you again. Everybody, thank you for tuning in. I'm going to end the broadcast, and everybody, hope you had a good weekend. See you on the internet next week.